Donald Trump is turning ICE into his own personal militia. And today's guest, Professor David Noll, well, he saw it coming. In October 2024, he predicted that the MAGA movement would turn vigilante violence into official state policy. And now, less than 1 year into Donald Trump's second term, those warnings, well, they have come true. Now, by the end of this video, Professor Noll will tell us what state sponsored vigilantism looks like in practice and how close we are to authoritarianism in the United States. But first, subscribe to this channel to stay informed about how you can help defend democracy. Professor David Noll, welcome to Defending Democracy.
Great to be here with you.
Well, a year ago, you wrote a book or published a book called Vigilante Nation: How State-Sponsored Terror Threatens Our Democracy. And it turned out to be, unfortunately, I would say, as an American citizen, quite prescient about how we have all spent the last 10 months. You talk in the book about MAGA Republican and its strategy to roll back political rights and also to undermine democracy. So, why don't you give us your assessment of where we stand now? Unfortunately, less than a year into the first year of Donald Trump's second term,
Mhm.
and really a year after you wrote the book.
So, my co-author John Michaels at UCLA and I wrote this book because we felt that there was, there's this massive body of books on Trump and Trumpism and what's happening in our politics, and we thought that those discussions, while valuable, were missing the extent to which the use of vigilante power was central to the MAGA movement. And we were seeing at that time in the States an effort to institutionalize vigilantism, to take the sort of energy that you saw on January 6th and give it legal cover and really make it an ordinary part of our politics. So our book focuses largely on what's going on in states like Tennessee, Texas, Florida, and we document a series of moves where state legislatures and state executives are essentially rewarding or giving legal color to what we would ordinarily think of as vigilantes, right? People who undertake to enforce the MAGA agenda on their own. So that was a 2024 book because
Right,
we were
that was the optimism.
that was
That
right.
was the
This
optimism
is the
moment.
call to
It's gotten
action.
worse since then.
Yeah, I need to emphasize we wrote this before the election, and sort of one of the messages of the book is there is a threat here because these policies are being prototyped at the state level. And we wrote a piece which I think was in Slate, right before the election, where we said, "Look out!" Right? If MAGA prevails in the election, as in fact happened, you have a set of policies that have been put in place at the state level that are ready to be adopted as federal policy. And there's a very quick transition from what was happening in the states when it comes to, say, attacks on diversity or efforts to dismantle public health agencies to the federal government. And all of those policies suddenly start reappearing in executive orders and become executive branch policy that the White House is directing agencies to put in place. So,
Yeah.
I'm sad to
So
say
let
we
me
called it, but I think there's a lot of lessons there in sort of thinking through the response to what states did and how people can be responding to the abuses coming out of the White House right now.
Yeah, so I want to stick with one of the themes of the book and bring it into the Trump administration, which is this unique notion of state-sponsored vigilantism.
Hmm.
In other words, when people think of or state-supported, I guess is a better term, vigilantism. When people think of vigilantism, they usually think of something that is happening completely outside of the processes of the state, right? You think
Right.
of people acting actually in contravention of the law. Um, so can you just unpack and maybe contextualize for people with what you've seen in the last 10 months? Or, kind of like what does it mean for something to be state supported vigilantism?
Right, and we fully sort of embrace the tension there because, you think of Batman, you think of Bernie Goetz, you think of Daniel Penny more recently, right? These are all people who acted without government authority, and without authority of the law. So, what John and I do in the book is we say, look, that might be the idea of vigilantes that we're familiar with from, from 24 or from popular media. But when you dive into US history, what you really have to worry about is private actors who are undertaking those kinds of actions. So, right, it could be, militantly policing where racial minorities are allowed to go, whether they're allowed to vote. It could be enforcing gender norms, right? It could be enforcing, who's allowed to vote, who's allowed to run for office, and they engage in vigilante tactics, right? Intimidating voters, right? Engaging in skullduggery, and what what we see when we look at American history is that there's a tradition of anti-democratic parties, which I should note has changed over the course of American history, right? It hasn't always been a Republican Party problem. Um, Coming along and trying to make those vigilantes' actions legal. So the classic example of this, and the tragic example of this is, of course, the way that the Jim Crow South operated, right? You would have scores of ordinary white citizens who thought that it was their role to enforce white supremacy and to keep black people out of public spaces and to keep them from voting and really sort of to punish any sort of perceived infractions against the superiority of white people. And they would do things like engage in murders, right? They would, engage in milder forms of harassment. Elections were completely crooked. So, right, even where voting rules were relatively liberal, there was pervasive violence. There were threats. Um, and when we talk about state-supported vigilantism, we're talking about using law and using legal power to endorse those efforts. So, a really simple example is in her book By Hands Known, Professor Margaret Burnham talks about murders of Black citizens during the Jim Crow South. And systematically, those weren't prosecuted. So, right, when a prosecutor tried to secure an indictment, right, the grand jury simply wouldn't return an indictment. Or if a case got to trial, juries in the Jim Crow South would engage in jury nullification. Or in the rare cases where somebody was convicted, the governor would come in and pardon the defendant. And so what you see is this blending of the classic kind of vigilantism that we know from pop culture with the really concerning piece of legislatures, governors, prosecutors, jurors, right, saying, yes, right, that's legal, but we want that, and using state power to legitimate that. And that, I fear, is what we're seeing at the federal level now, beginning, of course, with the notorious January 6th pardons, right, where you have a massive number of defendants who have received due process, who have been tried and convicted, or either convicted or agreed to a plea
Pled
bargain.
guilty in
Right,
some
and
instances.
they're released. Right, that we're literally releasing those vigilantes from jail.
And so what becomes of that? In other words, so one of the things I've worried about and I've talked about, but in fairness, I'm not sure we've seen, is that you now have sort of the core of a group of people who were engaged in January 6th have been now valorized. Donald Trump has embraced them. And, you know, do we have to worry that this now perpetuates itself moving forward? Is what we're seeing with the use of government power, and it is government power, it's not vigilante power, but government power by ICE agents being masked, which certainly has the feel of something that looks more vigilante coded, even though it are government agents. Like
Hmm.
where do you think we are now, and where do you think we go? I'll be right back with more of my conversation with Professor David Noll in a moment. But lawyers are on the front line in the fight for democracy, but we all need to do our part to fight against Donald Trump and his authoritarian movement. That's why we need your help to hold Trump and the Republican Party accountable. For just $10 a month, you can support Democracy Docket and get access to its exclusive events, insights from me, and much, much more. Become a premium member now by clicking on the link in the description below.
There's a number of scholars who have said that we're, sort of in the process of consolidating authoritarianism, and I agree with that assessment. When sort of look at Trump's aspirations, or if you look at the aspirations of the extreme parts of the MAGA movement, the goal is a society, a government where your friends are rewarded, your enemies are punished, and everything is bent to the leader's will. And that's obviously at war with rule of law, constitutional government, everything that's great about the United States. But we're not there. I came to work today, and I wasn't stopped by masked officers on the street. If you take to social media, or if you go to the No Kings protest, you can see that we have a thriving and vibrant protest movement in the United States. And so when I say we're in the process of consolidating authoritarianism, we have the first steps in the process that scholars tend to see on the road to authoritarianism, right? So you have Trump winning a legitimate election, which is oftentimes, in countries like Turkey or in Russia, the first step on the road. But then, right, the challenge, if you're thinking like an autocrat, or if you're thinking like an authoritarian, is how do I eliminate the threat of electoral competition? How do I make sure that I'm not embarrassed by late night TV talk show hosts, right? How do I intimidate university professors or law firms or media companies into supporting my program? And there's a series of moves coming out of the White House that are broadly directed at that. So, I work in a university, and I'm of course very familiar, right, with illegal efforts to manipulate university funding to push universities towards adopting specific ideas, right, specific truths, which is it's just at war with the idea of academic freedom, because we like to debate stuff and we don't like people telling us what is orthodoxy and what we can think or not. You see, the executive orders directed at law firms trying to eliminate lawful legal opposition to the Trump regime. You see things like OMB messing with appropriations. If a local school district deviates from the official orthodoxy, say, it's a shame about that funding that you were counting on to pay your special ed teachers next year. Either conform, or the checks are going to stop coming. And so we're in a moment of tension, right? There are millions of people who recognize that this is not right. This is not constitutional government, right? We're seeing an attack on the rule of law. We're seeing an attack on due process and the way the Constitution is supposed to work. On the other hand, right, you have a very ambitious White House, and they think, and they have persuaded some people that their 49% popular vote victory represents a great mandate to do whatever they want and to impose their will on American society.
All right. So, one of the reasons I wanted to have you on is precisely because you are a law professor, and therefore, two of the vectors that I am most focused on in my own life, and I think the audience finds interesting, you touch. And so, I want to start with the law part of it. Because it feels like, and here I'm not just talking about the capitulating law firms, but actually more broadly, the way in which the Trump administration has approached rule of law, the way in which lawyers who are working at the Justice Department have defended those policies, the way in which law firms have capitulated, the way in which some judges have stood up, right? It's a mixed bag, right? But
Mhm.
but but there's no doubt that central to this crisis of American democracy that we are in is the role of lawyers, law firms, law professors, judges, prosecutors. Right? Maybe it's a unique aspect of the American culture that everything eventually becomes a legal dispute. But certainly it is right now. So as I look at it, you have probably the only portion of the government that is doing anything to stand up to Donald Trump is the judiciary, right? Congress in the hands of the Republicans are doing nothing. The executive branch, he has completely taken over. So that's to the good. When you look at the legal profession as a whole, I think it's honestly, as I assess it, a much more mixed bag. Um, it's not just the law firms that capitulated, but you're not seeing a lot of big law firms putting their names on pleadings challenging these actions. It's mostly nonprofit legal organizations or small law firms. So talk about both your assessment of that, where you agree and disagree, but also why it is that the legal profession uniquely, if you
Mhm.
agree that the legal profession uniquely plays such an important role in combating authoritarianism.
Yeah, well, let me start with that famous quote from de Tocqueville, where he said, observed that in the United States, everything becomes a problem for the courts, and it becomes a legal problem. People, tend to invoke that as as a symbol that lawsuits are out of control, and sort of trial lawyers are ruining everything, and he's sort of imposing a litigious society on us. But whenever I talk about this in class, I emphasize there's a fundamental lesson there about the rule of law in the United States that we shouldn't lose sight of, because the idea that everything in the United States becomes a legal problem implies that the rule of law matters, and we care enough about the rule of law to take something to court and to contest whether, say, the state of Illinois is in such a crisis that federal law cannot be enforced, or the state of Oregon, right, is in such a state of crisis where federal law cannot be enforced. And so, I teach in a law school. I teach law students from every possible background, every possible politics. But part of our training and part of our ethos is that commitment to the rule of law. The idea that what we're doing here is about the principles, it's about the way that constitutional government works, and it's not about Kamala Harris or Donald Trump or whoever happens to be the leader of a political party at a particular moment. And so when you consider the way that lawyers are trained, the lawyers are socialized, and we spend hours, we spend years thinking about what the law requires, and oftentimes it's contested, and oftentimes we spend our entire careers fighting about it, as you well know. Um, I think that ingrains in you a certain respect for the rule of law, and a certain horror when somebody says, "Oh, I have Article 2. All this legislation that Congress has passed doesn't really make a difference. Yeah, all this stuff we built up over the 20th century. No, no, I won an election, so I don't need to follow those laws. I don't need to follow the appropriations that Congress has enacted." And so, as you were saying, right, where we're really seeing institutionalized opposition to this consolidating authoritarianism tends to come from the courts. And I would even draw a distinction between the lower courts, the
Right.
district court judges, uh, and tragically, the closer you get to the United States Supreme Court, um, I'm not convinced that most of the justices are themselves Trumpists, but they're working out of a position where they ideologically agree with so many things that he wants to do, that it becomes very hard to distinguish what they're doing from, essentially being, a party judge who simply rules in favor of the regime. And so where you're really seeing, this is an overly long answer, but right where you're really seeing concerted opposition, concerted insistence on the rule of law tends to be in the federal district courts, where judges are working with the law every day, where judges are used to engaging with lawyers, where when you make a decision, you can't just rely on some facts that somebody invented in an amicus brief. You actually have to provide a record citation to it and provide competent evidence to support what you're saying. So, in a sense, it doesn't surprise me that district courts have been among the strongest actors resisting the power consolidation that's going on.
Okay, so that's to some extent, the positive case, the courts. Let's talk about the legal profession and the lawyers. I've
Mhm.
been very critical. I've been outspoken against the law firms that capitulated. I have been outspoken, frankly, about a lot of the big law firms that didn't formally capitulated, but have basically cut back their commitment
Mhm.
to doing pro bono work that is pro democracy. And of course, we can't write out of the lawyer's story the fact that Pam Bondi is a lawyer, the
Mhm.
fact that the person who brought the indictment against James Comey is a lawyer,
Mhm.
right? There are lawyers who are defending sending migrants to foreign gulags, And I wonder if when you look at the historical examples of how democracies move to more authoritarian regimes, if there are any lessons about how lawyers wind up fitting into or resisting those efforts that are relevant to us today.
Mm. Well, I guess let me preface this by going back to Jim Crow because that's the period of history that I know the most about. And let me, I'll do something weird. What will probably be weird for your listeners is to imagine, yourself, put yourself in the position of a Jim Crow governor, or really any aspiring autocrat. We started by talking about vigilantes and the role that they play, and it's obvious to see why it's attractive to a figure like Trump to have an army of vigilantes to impose his will when, say, he doesn't win an election. But from the authoritarian's perspective, relying on those sort of totally unstructured actors is risky because they're not part of a formal organization. They don't take a legally binding oath to right to following your instructions. They're difficult to control, and so right across authoritarian regimes, whenever you see brown shirts, whenever you see vigilantes, right, one of the problems for political leaders who make use of them is that they tend to go nuts, right, and they tend to do right things that are dangerous, that hurt you politically, and so on and so forth. And so the move is to take those and regularize them and institutionalize them. And this is really where lawyers come into the picture. Because, just to take the most obvious example, how do you build the bureaucracy that's needed to do mass deportations, including deportations of people who have been here for decades and had no interaction with the law and contributed productively to American society? That's not somebody who, that's not a function that somebody who was, attacking the Capitol on January 6th can do. You need a lawyer for that, right? You need somebody who
Right.
understands rules. You need somebody who understands process. And so lawyers, as you alluded to, are being asked to do this work of building the process, building the institutions that are necessary to carry out this mega vision. And on one hand, it's something that lawyers are good at because they understand how process works. They understand how to put rules in place. They can write opinions that say, oh, right, when you do this, it's actually fine, right? We're not going to prosecute you for that. But it also involves, right, a fundamental betrayal of what lawyers should really care about, right? All that, all the process stuff, I teach administrative law. So, we work with regulations. We
My,
really,
my condolences.
yeah. But, sort of all of that depends on a functioning constitutional government and respect for separation of powers, right? And the idea that the president is constrained by law, that the president isn't an autocrat who can do what he wants. And so one of the divides you're seeing, I would say this, you see this most starkly between the enablers of the regime and folks like you who are filing lawsuits, to stop some of these abuses, is people who sort of understand the broader stakes, all right, understand what they're being asked to do. Now, that does leave a huge center, right? You have the Paul Weisses
Right.
of the world, where I was a summer associate, so I have to uh, confess my association with Paul Weiss. I think there is, in these big firms, you see it in a lot of media organizations, and I honestly don't know quite how it took hold, but there's this narrative that when Trump won 49% and change of the popular vote, that wasn't the result of a historically weird close election where the Democratic Party changed nominees halfway through and all this other weird stuff happened and we were still dealing with the effects of inflation. But it was instead a decisive ratification of every MAGA grievance, ranging, from, complaints about investigating Trump's connections to Russia, to people who don't want to have trans kids in their school. And I really I don't understand how law firm leaders, and I don't understand how media leaders have talked themselves into this because it was yet another close election after a series of close elections. Neither political party is delivering what the voters clearly seem to want from the federal government. And yet there's a sense, among law firm leaders, among university leaders, among media leaders that it's all of a sudden verboten, right, to take a position that's at odds with the regime. Or to right, even insist on things like ensuring that the law is complied with before funding is yanked to an institution. And so when you look at that vast, sort of middle of American society, I think there's a lot of that going on. There's a lot of sort of just really fuzzy thinking about what Trump's victory means and what lessons to take from it.
Yeah, so I'm going to offer a response to that, or a sort of a not a counter framing, but a framing of it that I've started thinking about, which is in both big media and big law. I think two things happened. The first is that what began as professions and callings turned into primarily for profit ventures. Now, that doesn't mean the law wasn't always for profit. It doesn't mean that media has not always been for profit. But what it means is that law firms, and when you teach your law students, you still tell them that you have to put your client's interests above your own, that the role of a lawyer is to serve their client and serve the court, to have they have duties to their client and the court that are above their own economic interest. And I think that's how journalists have traditionally thought of themselves. And I think that the truth is that large media corporations today, they just like that isn't how they see the world. And they're just large publicly traded companies that are just as happy to sell widgets as they are to do journalism. And I think among big law, they have gotten so large that and have made so much money for their partners that they too have sort of become more divorced. And I think coupled with that is something that I find even more inexcusable, which is that there is both good lawyers and good journalists have historically viewed themselves in a quasi adversarial relationship with the government. Our judicial system works on an adversarial system in which each side has lawyers, and they they represent their client zealously, and eventually a resolution is either accomplished through a judicial proceeding or a private proceeding or a merger or an acquisition, whatever it is. But there is a tension that is going on here, and what Trumpism has represented, I think, in both professions, has been a different model, which is essentially an access model, a
Hmm.
model that it is not actually about being adversarial with the regulators. It is about being their friends and being able to get special favors from them. And it's not about being adversarial with the White House. It's being able to get stories handed to you that are convenient for all involved. And I think it's that demise of that adversarial system that is, to me, part and parcel of what this authoritarian is trying to do.
Yeah, I think there's a lot of truth to that. Sort of one of the things that has really caught my eye over the past couple of months is that the Wall Street Journal, of all places, has been
Yeah.
running a series of stories on the rise of state capitalism. But right, by which they mean overt government interventions in the economy of the type that we might expect to see, say, in China, but that have traditionally played a less important role in the United States. And it's just fascinating to read these stories in the journal because they're reported as straight stories, but there's clearly sort of a Hayekian free market thinking that's behind them. Sort of because sort of from classical libertarian premises, sort of the idea is that well, if the government is picking winners and losers, that is directly at odds with the capitalist system where we rely on the market to do that. And furthermore, we know looking at the 20th century that when the government starts picking winners and losers, that as a historical matter tends to be associated with the worst totalitarian abuses. And so you have, this series of stories in the journals where they're saying, just as China supported such and such chip maker, right, or such and such,
Right.
right, manufacturer, right, look at this deal, which is seemingly patterned off of what was being done, right, in those, avowedly communist governments being replicated by the Trump administration. And I think you're right that, right, when you look at the client rosters and the deal books that some of these law firms have, they have, right, they've integrated themselves so much with the government that if sort of traditionally the understanding was that the government would follow the rules and the government
Right.
would respect the rule of law. And, for a long time, you could sort of get very integrated with the government and have that protection. Say, oh, we're protected by a federal regulation or we're protected by a statute that somebody enacted. And, that's going to keep the government from retaliating against us. If you loosen that constraint, if you loosen the idea that the executive branch will comply with the laws enacted by Congress, everything starts to fall apart and very quickly because, right, this whole system, right, depends on coordination, depends on respect for the rule of law. And if you have an executive branch where the attorney general says the president can do no wrong, or, right, my Article 2 gives me the authority to override the laws enacted by Congress, well, all bets are off.
All right. So I want to pivot to an area that I focus on a lot, which is uh, voting in elections. And you have also expressed a lot of concern about this. I'll lay my cards on the table. We are going to have elections, as I oftentimes say. Autocrats love elections. They
Mm.
may not like free and fair elections, but the pageantry of elections are one of their favorite things.
Hmm.
And we have a long tradition of localized state and localized elections that I think will serve us well. That said, the question is how fair and free they are,
Hmm.
because there's no that's a continuum, right? There's no such thing as a perfectly fair and free election, and we're not going to have completely unfair or no elections. So it's going to be we're on that continuum. We are, and I think they are going to be less fair and free than they would have been if Donald Trump had not won,
Hmm.
and probably less fair and free than we have seen in recent election cycles. So
Right.
they will be worse in that regard. Um, that's my take on it. What do you worry about in this regard? And do you think I'm being too optimistic, too pessimistic? How do you see it?
No, I think you have it just right. I think our history, if you look at the entire history of the United States, is of elections that are severely wanting from a democratic perspective. Right? It's really only since the Civil Rights Act and the Voting Rights Act that we have something that looks like what political scientists would say is a real democracy. And to its huge discredit, the Supreme Court has dismantled large parts of the Voting Rights Act. And we've seen enormous retrenchment follow from that. So I think you're right that we'll certainly have elections. I think you're right that there will be major efforts to sort of tilt the Democratic playing field or to ensure that they come out a certain way. So how's that going to happen? Here are the things that keep me up at night. One, which John and I talk about it in the book, is partisan takeover of those key local elections offices. So think back to 2020 or some of the earlier election cycles where there were threats against election administrators, where there was, examples of political violence. The way that scholars usually think about this is we assume that there's sort of a nonpartisan election administrator who's been doing it for 30 years and who knows how the rules work and isn't gonna tilt the rules in favor of one side or the other. And there's an outside actor trying to force them to violate their oath. That is not the world we live in now, right? Whether we're talking about Georgia or Arizona or any of these key battleground states, there has been a movement led by, among others, Steve Bannon to capture control of the precincts and right to capture those local election offices. And the people who are exercising those roles are steeped in the right-wing information environment. So to them, it is taken as right for granted that Trump won in 2020. It's taken for granted that all of the conspiracies that you hear about in whatever your favorite right wing information source is true. And so you have this key nonpartisan role being performed by people who are members of the MAGA coalition and by all of their theories about what's been going on in the United States. So that's one. Number two is obviously just overt political violence. This has
Mm.
been an absolutely terrible year for the principle that we settle our differences through politics rather than through violence. And the partisan valence of that is very mixed. Sort of over the historical trend, we've tended to see political violence being used for anti-democratic purposes. But my non-expert read on the situation is we're just seeing a lot of disturbed people, right? A lot of people in very difficult circumstances engaging in acts of violence. And one, you can see that interrupting an election and sort of changing the way an election is administered. More worryingly for me is that that could become the pretext for a large scale clampdown on civil society. So Daniel Ziblatt and Steve Levitsky have a great essay back in 2019 called "Why Authoritarians Love Emergencies" or something to that effect,
Mm.
and they make the point that um, authoritarians, like other politicians, are always trying to rally popular support, right? Oftentimes these programs are not, what they're doing aren't popular, and we're seeing that in the polls right now. But one of the things that we know causes people to get behind the president or to get behind other elected leaders is a crisis. And so, if there is a crisis of political violence in connection with the election, then that it presents an opportunity for a moment of authoritarian consolidation, both because people will rally behind the president and because emergencies unlock all kinds of powers that the president or doesn't ordinarily have. And then sort of longer term, I worry about the dismantling of the Voting Rights Act. And I worry
Right.
about these big structural moves that are perhaps, they're very familiar to folks like you and me who watch what the Supreme Court is doing. But I'm not sure that sort of the ordinary voter or the person casually watching the news understands to what an extent the Supreme Court has taken away protections against, any number of attacks on the democratic system, whether it's gerrymandering or whether it's racial discrimination voting or whatever have you. And I wish I knew sort of an easy way to get them back, but right, the health of American democracy depends upon robust legislation protecting the right to vote, protecting people's right to be fairly represented, and through the entirety of the Roberts Court, if not earlier than that, right? Those protections have been taken away.
Yeah, and we are. This is not a theoretical matter. I mean, the fact is that the Supreme Court heard a case last term out of Louisiana that should have been a very easy case. My law firm was involved in that case. My law firm was involved in the prior Alabama case as well, where the Supreme Court seemingly reaffirmed the Section 2 of the Voting Rights Act, which is the main provision still in place, the Milligan versus Merrill case. But then comes this case out of Louisiana, which is essentially a group of white voters who
Hmm.
are saying that the map that the state of Louisiana drew in order to comply with a court order, a federal court order, that to remedy Louisiana's prior violation of the Voting Rights Act,
Hmm.
right? So Louisiana gets sued because they violated the Voting Rights Act. Judges agree that they violated the Voting Rights Act. They are ordered to draw a new map to comply with the Voting Rights Act. They do. A group of white voters come and bring a case challenging that. And the Supreme Court takes the case and hears it last term. And we're waiting and waiting and waiting until the end of the term for this, what seemed to be a relatively easy case. And instead of deciding it, the Supreme Court actually sets it for reargument
Hmm.
and this time tells the parties, by the way, we want you to brief the question of whether Section 2 of the Voting Rights Act remains in force at all, whether it's just unconstitutional.
Hmm.
Not something that either the white voters had raised, not something the state of Louisiana had raised, not something the Department of Justice had raised, right? Just like the court just decided this was on their mind, I guess, and that they wanted this re-argued. And they set it for argument in early October. And that I guess in some sense makes sense since it's a re-argument case. But I am haunted in some sense by the fact that, in 2009 they heard a case involving a campaign finance
I was gonna
question of
say.
how pay-per-view movies would be treated under the
Mhm.
campaign finance laws. Literally, that was the question: is
Right.
whether pay-per-view movies are covered or not covered by a particular part of the campaign finance laws. And at the end of the term, they said, "Well, no, we actually want you to re-argue that
Mhm.
on a broader question." And that, of course, that case was Citizens
Mhm.
United, which gets decided on January 10th, very early in the term, very early in the calendar for the election year.
Yeah.
And so I don't want to be conspiratorial about this because I'm not, but it is certainly possible that the Supreme Court could strike down this provision of the Voting Rights Act in early 2026. And then you see mid-cycle redistricting
Mhm.
across the board in all these southern states. And you know better than I what that would yield.
Yeah, I think, let me say in response to that, or let me follow up on something that I was saying before about the relationship between MAGA, and what the Supreme Court is doing. I don't think that the majority of the court, is a MAGA court in the sense that they would show up at a rally and say, "Mr. Trump, or, you're the greatest. Your hair is
Right.
beautiful. You're in excellent physical shape, and you're the best at golf." But they do have a set of ideological commitments which aligns perfectly with Trumpism, and they've shown no self-awareness whatsoever about how they are enabling the project. So the ideological commitments that they're dealing with, right, they're an older set of conservative commitments that come out of the Nixon and Reagan administration, right? So this idea that the Voting Rights Act is, a huge intrusion on state sovereignty, and that these states, which had a history of de jure segregation in voting, are the real victims here, right? They're right. Nasty Congress is coming along and telling them that they have to do X, Y, and Z to protect the rights of people to vote. Um, and so right, and that's their ideological project, and it's been unfolding over decades. And it's just been astonishing to me that they haven't hit pause on that, right? As all there's a time and a place for everything, and I guess even if you think, which I don't, that the Voting Rights Act was this abominable piece of legislation. Um, the justices have a lot of discretion about
Right.
issues that they take up, the cases that they take up, whether they rule broadly or narrowly, and they're almost drunk on sort of the opportunity to put in place this older conservative vision of how elections should work, of how executive power should work, and, sort of to the extent that they're aware of what's going on, it seems like, they don't care. It's like, "Oh, this is just how politics works." Politics is dirty, politics is nasty. Things will, you saw this in the gerrymandering case most infamously.
Yeah.
Everything will work out. Politics
Right.
is messy business, and there's not really any place for equal protection of the law, or um, protections against discrimination, or protections against other abuses in the voting process.
So I have to ask you two jurisprudential questions since I've got a law professor and you sort of alluded to both of these.
Mm.
The first, maybe it is the era in which I went to law school. I graduated law school in 1993. And so we were constantly being lectured that conservatives had a coherent ideology, a coherent jurisprudence, that it might not be mine, but that it was sort of blind to the facts. It was just let the chips fall where they may.
Mm.
And two of those principles were um, sort of originalism of constitutional interpretation. What did the founders mean at the time they wrote the Constitution? And federalism, the belief that, as you say, you should not have the federal government unnecessarily trampling on the roles of states. And so, two questions I have for you on two different cases. So you can you can take this as rapid fire or long fire or a long answer, however you want. But the first is on the Voting Rights Act. Section 5 of the 14th Amendment and Section 5 of the 15th Amendment give Congress explicitly the power to enact legislation to effectuate those amendments, and
Mhm.
those are the post-Civil War amendments that include the right to vote for black men originally. Now it includes women after the 19th Amendment, and the 14th Amendment, which has equal protection of the law. And so one would think a strict textualist or an originalist of the Constitution would say, okay, well, you know, let me read the text as it is. It says Congress can pass this legislation. So Congress passed the Voting Rights Act. That's check. Then you'd say, okay, well, what did the founders in the post-Civil War, as the country was mourning its dead, as cities were ablaze, as the Union had come within a hair's breadth of folding, it is hard pressed for me to imagine that the framers of those amendments were overly worried that the feelings of the southern states would be hurt. If Congress passed a law to protect black voting rights, it doesn't seem to me there'd be an obvious like originalist argument to say, oh no, what they were really worried was that state sovereignty might be trampled on. The rights of Alabama would be impinged upon by this terrible federal law that Congress passed. So that's number one. But let me give you my second one, and then you can answer them together, which is at the same time that you say that the conservatives on the court are worried about what I'll call federalism concerns, you are watching the president of the United States deploy other states' National Guards, like
Mhm.
literally saying, I'm going to take from state A and send those National Guard to state B.
Mhm.
And again, it's a little hard for me to take seriously that that all of the people who told me they were really concerned about states' rights, they were really concerned about the rights of states to not be trampled upon by the federal government, are now going to say this is okay. So I don't know how you want to unpack those two sort of rants of questions, but am I missing something?
No, well, let me start with the Section 5 question, because I think what the court's done there is absolutely indefensible on originalist grounds. For folks who haven't read up on sort of what was happening in Congress following the Civil War, um, this was a Congress which was confronting, one, states that had seceded and formed the Confederacy and fought a bloody civil war against the Union, and two, a Supreme Court that prior to the war had infamously issued Dred Scott, which was overturned in Section 1 of the 14th Amendment, and more broadly was trying to manage the slavery question itself. And, much as, in some of the court's decisions, you get a feeling of John Roberts trying to manage the politics of the situation, right? The Tawney Court of that era was, giving a little to one side, giving a little to the other side, trying to put off resolution of the difficult issues. Of course, it completely failed, right? And Dred Scott is among the factors that led to the Civil War. So go back to what Section 5 means when it says that the Congress, right, can enforce this through appropriate legislation. It is absolutely insane to think that a Congress that saw itself as the protector of civil rights in the former states of the Confederacy would say, you know what? Our authority to enforce the 14th Amendment, actually, the Supreme Court has to find a constitutional violation first. And the Supreme Court's understanding of the constitutional violation has to match up with our understanding of the constitutional violation. Oh, and by the way, among the principles that we, the Congress, are going to respect is a principle of equal parity among the states, which John Roberts dreams up in the 21st century. You don't even have to be an originalist. Just read the text of Section 5. And so, one of the ways the court is failing right now is to be principled in its textualism and principled in its originalism. And if you look across the sort of the Supreme Court's docket, which thankfully is not that large these days, um, the application of originalism is almost haphazard, right? And there's an obvious partisan valence to when the Supreme Court deploys originalist reasoning and when it doesn't. So, I guess that's my take on Section 5. Remind me of what your other your other exam question was.
The deployment of National Guards from one state to another.
Oh, right. I mean, so, as with everything the administration is doing, lawsuits are flying left and right, and it's, that's part of the program is, making it difficult for us to keep up with, and I say that as someone whose job is to keep track, of this stuff. Um, but, there's clearly, an intrusion on states' rights in just the most basic everyday sense. If you have 400 members of the Texas National Guard, I guess being deployed to Chicago to protect ICE agents as they are rounding up, um, landscapers in suburban Chicago. So there's, there was the American prospect of this wonderful issue before the election called the Cold Civil War that was framed around the question, when will the Cold Civil War turn hot? I'd submit that sending National Guard troops
Hmm.
from one state into another is getting pretty hot. There may not actually be battles on the street, but a show of force is starting to look very worrying when you zoom out and you consider other countries that have gone through democratic backsliding. So the question is, again, we see district court judges
Right.
um, recognizing the constitutional stakes and using
But wouldn't this Supreme Court be sympathetic to the states normally?
one would think. But there's a but. There's two competing impulses that are going to be at
Okay.
play as the case makes its way up to the Supreme Court. One is this idea, which is very popular with some of my friends in the legal academy, that the courts have been out of control. And as bad as what's happening in the White House is, as bad as things have gotten, the courts have been just as bad by not respecting, the obligation to only decide cases and controversies, by issuing injunctions that are too broad, by not, crossing their T's and dotting their I's. And so, you saw this in the Trump versus Casa case,
Yeah.
sort of disapproving the use of nationwide injunctions that the Supreme Court issued. So there is, right, as all of this is happening, our Roberts Court majority is saying this is the time to really cut back on the power of courts and make sure they conform to this historical model that we have in mind of how a federal court should operate. And of course, the other piece, which sort of runs through all of the various emergencies and all of the various crises we're living through right now, is the unitary executive theory. And to the court, that is as important, probably more important than the value that they attach to states' rights. So I'm
Huh.
sure you've talked about it on the show, right? But the unitary executive theory
Yeah.
is the idea that the executive branch is the president, right? Congress cannot legitimately create departments of government and insulate them from presidential control, right? Congress cannot say that vaccines shall only be approved if experts in the field say so, right? It's viewed as an intrusion on the president's authority to limit his ability to tell the millions of people who work for the executive branch how to do their jobs. So when this case comes up, right, on one side, there's going to be, right, massive federalism concerns because there is a literal armed incursion on, in this case, Illinois, Oregon. On the other hand, you have the court's infatuation with the president, right? And the court's view that both the Constitution and the statutes that Congress has enacted give the president something like dictatorial powers, at least when it comes to the operation of the executive branch. So,
All right.
regrettably, I don't have particularly high hopes for the courts, but I'm an optimist. I think they're swayed by public opinion. I think at the end of the day, what we the people think matters a lot more than what the courts think, and so I'm not
So,
throwing in the towel yet.
all right. So that is going to be my final question to you. So you obviously you study the courts, you study what is going on in the legal profession, but you interact on a daily basis with young people who are studying to join the legal profession, right? These are students who at your law school who are really at the beginning of their career and are, looking at a world in which the case books they are being handed on day one, you know, are then outdated by the time they get to, the midterm.
Mhm.
They are watching as principles that they grew up believing were settled rule of law issues
Mhm.
being seemingly set aside. They're seeing what looked to be to them and to me and to you, I'm sure, to be grave injustices
Mhm.
being committed in the name of the United States on the streets of Chicago and around and in communities all around the country. So you are left in the unenviable position of when those students come to you and say, why should I have hope? Why should I believe in rule of law? Why shouldn't I just view this all as power? The most powerful gets what the most powerful wants.
Mhm.
What do you tell people? You said you're an optimist. So what is that message of optimism?
Well, let me put it this way. There's no denying that we're in a constitutional crisis. I don't think you can look at a newspaper and see people being summarily deported to El Salvador with no legal process based on a fake national emergency and sort of fake designations and say we're not in a constitutional crisis. What I tell students, and what I tell them when they ask, "Why should I be focusing on, reading these statutes and learning the law, given everything that's happened?" Is that crises don't last forever. Jim Crow didn't last forever. Nazi Germany didn't last forever. Any number of smaller scale authoritarian projects didn't last forever. Oftentimes, we have these crises, we have these authoritarian moments, and they lead to a rebuilding of the system. So, the Great Depression hits, and we get the New Deal, and there is a new legal order that comes out of that, right? If you went to law school in 1920, being a lawyer in 1935 looked very different, and you would probably be aghast at what happened. But zoom out, and from a long-term historical perspective, we go through these periods of crisis and recovery. And that's my read on American history, right? Is that it's not, a single, a straight line towards a more just and equal society, but we have movements and counter movements, and one step forward and one step back. And wherever the politics settles, we're going to need people to build those institutions that come next. They're probably, sort of a lot of the stuff we're fighting about now is stuff that was created in the 20th century. The agencies that Russell Vought is dismantling, they're created in the 70s, they're created in the 60s. They're the past generation's understanding of what federal government should look like. Um, they're not going to survive in their present form, right? There's still going to be a need to get people disability checks, or to protect the rules of the democratic process, or to protect people from being ripped off by credit card companies. Whatever the policy problem is, this the institutions are going to look different. But again, this is a more hopeful story about lawyers, right? Somebody's going to need to create good institutions. Somebody's going to need to develop those, good rules for how we live together without descending into violence. And that, to my mind, is a much more positive vision of what lawyers can do, right? You can use your law degree to slash and burn and attack and litigate grievances that that emanate out of who knows where, or you could recognize that we're in a moment where really creative thinking about our government and our institutions is going to be necessary, and try and use law to improve that.